because I've pressed record again. I'm not seeing. Okay, now it seems to be recording. So I was sharing my screen with you, as you can probably see. And so all I'm showing you is a book, obviously, but this book was published last year. So it came out sometime last year. It's brand new. I'm the first person who's taken it out from the university library. And I have searched this book, and there's only one single reference to Jacob Zuma, and that had nothing to do with the way he was removed from office. It doesn't mention Thabo Mbeki either, even though the majority of the content of this book is precisely on the question of how leadership comes about. Now, in other words, whether a person becomes a president through an election or through a coup d'etat or after independence, as many presidents did become the president of the state in 1960, when the state, or about 1960, when that individual state obtained independence. And yet it does not mention the South African scenario as being an unconstitutional change of government. All it does say is it uses the Zimbabwean scenario to say that when Robert Mugabe was forced to resign, and this is actually identical to what happened with Jacob Zuma and with Thabo Mbeki, they were forced to resign by the party. In both of those, well, in all three of those instances, the most that these authors say is that it is a irregular situation, but it is not necessarily unconstitutional. And that is such an interesting area, because we want clarity. That's the whole idea behind the rule of law, is that there's certainty and clarity about what the law says and how it is applied. And yet when it comes to an issue that is of such significance, like, sorry, now I'm trying to remove pages. Sorry, let me get back to where we were and no longer having to share all my boring emails. We do need clarity, but at the moment, the best clarity we have is that because it is the dominant party that has the power to put the pressure on their president and say, we've actually lost all our faith in you as our president, but we are not going to embarrass you and subject you to the degrading and humiliating process of a vote in Parliament where we vote to remove you from office, and then you resign, you are forced to resign along with your entire cabinet, and that might leave a power vacuum. So that's the logic, is that the political party decided this is what is actually in the interests of the state, and to ensure some kind of cohesiveness in the party, where they, so let me put it to you this way. I have also, at some stage in my life, but never finished it, started writing an article on unconstitutional changes of government, and what it's sort of what the meaning is. And I ended up having to, when I was working out a potential title, I had to use this title of, is it solidarity that we're seeing, or is it discrete moral pressure, which I think is most important when we look at how Jacob Zuma was removed from office, because it was discrete moral pressure placed on him by the leadership of the African National Congress, saying, quietly, just leave office, go on television, resign, and move along. Because the alternative is condemnation. And once there's condemnation, it is going to cause conflict that is unnecessary in the African context. So I don't expect you to read this first paragraph of mine, but why I have this first paragraph of the document I'm referring to here is only because Mobutu Sese Seko was convinced that democracy is not for Africa. And when there was a coup d'etat in Guinea, equally, the army said they think we have a democracy here. So that's the irony, is that in Africa, we are perceived as being this continent that does not know how to follow the rules. We don't believe in democracy. We pretty much do as we please and to see how far we can stretch the law with and get away with it. So I don't think that I'm necessarily answering Gabriel's question as well as I possibly could. All I'm trying to illustrate to you is this is most certainly one of the many areas of constitutional law that is grey. There isn't a clear and definite answer because the political party has to function the way it believes is best for the interests of itself as the party. And if they are in government, they also need to consider the well-being of the state in general, because no political leader wants to have blood on his hands where there has turned out to be widespread civil war over who should be the president. And we see that all over the African continent. So are there any responses to that point? I can't see whose hand this is down here. Walter, yes, you can please give us a response.
Thank you, Professor Lee. I just want to point one interesting point with our case, which involved President Jacob Zuma and President Thabo Mbeki. Interestingly, is that both of them, when they left their presidential office, they gave their letters of resignation to the then Speaker Baleka Mbete. So in the history of the Speaker of Parliament in South Africa, Baleka Mbete actually received two resignation letters from I think that's an interesting point. But what I wanted to raise in view of what is we are discussing is that I think the pertinent question, according to me, is whether the Constitution provides for the incumbent president to resign. I think that is what we need to do, because the Constitution, as far as I'm concerned, is slightly silent in as far as resignation is concerned. Whether voluntarily or coercion, it's something else. But I don't know whether those who were writing the Constitution did not foresee a question of an incumbent president resigning. And I think maybe that is where the gray area is, unless there is some provision somewhere in terms of the laws of the rules of parliament, wherein there is provision for the resignation of the president. I suppose there should be something like that, because interestingly, both these presidents, they write a resignation, or they tender their resignation letters to the Speaker of Parliament, and not even to the Chief Justice. So I just wanted to make that point. Thank you.
Well, I'm going to answer you very briefly and then get back to the other questions. All I want to say is there is reference to a resignation, but it's only in terms of Section 89 in the context of where the president is no longer able to perform the function of office because he has suffered a heart attack or a stroke or is otherwise unwell. So you're quite right. The drafters of the Constitution didn't anticipate a resignation in any other circumstances. So that is why we're confronted with this grey area. But I do believe that it shows that, because in both instances, there were quite serious allegations against those presidents. In the case of Thabo Mbeki, it was that he had politically influenced a decision of the Ministry of Justice and the National Prosecuting Authority about when to arrest Jackie Selebi. And in the case of Jacob Zuma, there was this pressure because of the supposed links with the Guptas, which has now transpired to a formal commission of inquiry. So, yeah, it is a grey area, but the political parties themselves had to do what was best for the party and the state. And the point that you raised about that it was Baleka Mbete who received both letters of resignation, that is consistent with the fact that it is the National Assembly which appoints the president, and therefore that resignation should equally go back to the Speaker of the National Assembly, who is mandated to oversee the effective functioning of Parliament, who appointed the president. And so that is the correct forum that the president needs to resign from. So that is really why the letter of resignation had to go to the NA and not to the Chief Justice, because the Chief Justice only oversaw the inauguration but was not actually party to the initial election as to who would be the president. So the point I'm making is that this shows us how the executive and the legislature are constantly functioning in tandem with each other in a harmonious way, holding each other accountable, and the judiciary only looks on from the side and will not engage unless they are specifically asked to become involved in the issue. But Ngovela's hand is up.
Yes, good evening, Professor and fellow
Evening,
students.
yes.
I think I put the question that I wanted to put, though I would have put it in this manner, is probably need to ask a question as to, is it unlawful for a president, sitting president, to resign? But again, my take is this, that there's an issue, because if the president would have resigned, and probably in terms of Section 89 or 102, then the whole cabinet had to go. I think there's an issue of I would call it stomach politics. The other fellows felt it would be best if only you, number one, would go and the rest of us will remain so that we can continue eating.
Yes, that sounds very likely. I think that is a good analogy. But and more fundamental than that, though, is to ensure that from that day forward, there would be a continuous process of administering the state without having to hold entirely new elections and appoint a brand new president, a brand new deputy president, and an entire new cabinet, when there is already a system in terms of the political party's constitution to deal with such an issue in the way that is the most humane to the president involved. So it shows that they still respect the person and therefore don't want to prejudice him by denying him the benefits of pension, medical scheme, and any other benefits of office, but at the same time are indicating to him, we have lost faith in you, and if you don't resign, we unfortunately will have to invoke Section 102, which is going to be very damaging and embarrassing to you. So yes, I think it's a case of I think that sort of the lesser of two evils. Rather, let's just remove one person instead of having to remove an entire executive or the leadership of the executive of the state. So I did see another hand, but that seems to have disappeared. So Joanne, I don't know who was first. Joanne?
Hi, everyone. Okay, so
Hello.
my question is basic. I just want to find out, does the president benefit or does labor law also apply to him?
Interestingly, not. That is one of the such an interesting point, is that we have seen in the Similani case where the Democratic Alliance went to court and said Similani should not be appointed as the head of the National Prosecuting Authority. And the court agreed, and they said he doesn't have a right to the protection of labor law, such as procedural fairness and being given a warning beforehand or being asked to make representations about why he shouldn't be removed from office. And it's exactly the same with the president. That is the fundamental distinction between constitutional law, administrative law, and labor law, is that the three are separate branches of the law. And even though our constitutional court initially would complicate matters but by using labor law provisions when deciding administrative law cases, all of that has now been decisively resolved in a number of cases. Fredericks, I can't even remember the other two. Chirwa, it started with the Chirwa case, then Fredericks, where in those two cases, the court didn't quite know whether labor law applied in the removal of someone from office. And they eventually said, we now have unambiguously decided that labor law does not apply in the case of the appointment of someone in terms of a constitutional provision. That is a purely constitutional function, and therefore the law that applies is the Constitution itself, not any other law that has been passed or enacted to give effect to any other constitutional provision. So because it is the Constitution that unambiguously says the president is appointed by the National Assembly in terms of this Constitution, likewise, it is the Constitution that says the president can be removed from office, and there is no right of trying to claim that it's an unfair dismissal or something similar. Likewise, to bring this just to sort of what's happening currently in the news, and it has been clarified to a large extent in our courts, but because it is the National Assembly that appointed the president, and because it is the National Assembly that appointed the public protector, those two cases are actually identical. And we know that the Constitutional Court held in the EFF versus the Speaker of the National Assembly case of 2018, that the National Assembly must make rules for how it will remove the president. And it used the term impeach, which is exactly the same concept that is being applied to the public protector. She is being impeached because she is seen to be no longer fit to hold office. So it's in all material terms the same as Section 89 of the Constitution, which says that if the president has committed a serious violation of the law, and is unable to execute his duties properly, he can be impeached. That's really the same argument that's being applied to the public protector, is that she keeps making fundamental errors of law. There's evidence that she's been biased in certain cases. There's evidence that she has not actually been forthcoming with information when she's asked to produce information, and that therefore she should be removed from office, and therefore the Parliament is in the process of making sure that she is removed in a proper process, but not with any reference to the labour law principles. So I hope that answers your question, that you must remember that labour law does not apply when we are talking about the appointment of the legislature and the executive and even the judiciary. Labour law is not, it's a completely separate branch of the law and is not relevant in the constitutional context of a constitutional appointment.
So labour law is only for citizens.
Only for citizens who've been appointed in terms of the Labour Relations Act, and who have therefore signed a contract of employment between the employer and employee, and where there is now this dispute between them, labour law principles apply. But that's not the same at all with constitutional appointments.
Thank you.
It's really a straightforward matter of, if you've been appointed, and the president, the best example is the reshuffling of cabinet. If the president has decided he no longer wants you as his Minister of Health, he can say, I am reshuffling my cabinet. From today, we have a new Minister of Health. And the former Minister of Health, and I suppose that's the worst example I could have used, because I'm not actually referring here to Zweli Mkhize, it was just an example. The Minister of Health, in that example I gave, cannot try and go to the Labour Court and say, I've been unfairly dismissed. That's not how it works. It's, in terms of the Constitution, it's the prerogative of the President to appoint who he wants to his cabinet and to dismiss who he wants, unfortunately. Theo Duvenacher had a question early on, and then I've lost his hand. Theo, do you still have a question? Is Theo even still here? Well, while we wait for Theo to find his way back, Octavius, I think your hand was up before Zakele.
Hi, yes, thank you very much, Professor, and evening to the colleagues. I just wanted to sort of understand on the similar topic. The president is, of course, electing his cabinet to help him or assist him to, of course, run the business of the country. So therefore, they are all at his behest. So if he is then disabled, not physically or anything of that sort, but like he decides to resign, are they automatically also not disabled? Because they are actually not working on their own. Even if you're a Minister of Health or Energy or whatever it is, you are actually doing work on behalf of the president. So if he's not there, how are they able to just still continue? Should there not be sort of a, hold on, everybody hold on, up until we can maybe get an interim president, and then he can decide, look, I want you guys to continue up until I figure out my cabinet. I just wanted to get some clarity on that matter.
Well, we've seen that in practice, actually. When Jacob Zuma was forced to resign, as soon as Cyril Ramaphosa took over as the interim president, he did shuffle the cabinet, because it is imperative that the president has a good working relationship with his members of cabinet and can choose whoever he thinks is best suited for the particular roles. So that is actually one of the things that was sort of foremost in everyone's minds as soon as Cyril Ramaphosa took over in 2018 is what kind of reshuffle are we going to see? And because we had now been, all of our minds had been tainted by the Gupta leaks, emails, and all the information coming out, we were all intrigued to see whether certain ministers would be removed from office or not. And we did see some fundamental changes. So yes, you're quite right. The president must be able to choose their cabinet and dismiss members of their cabinet whenever it is appropriate in order to ensure the best possible service delivery in the state. So yes, that is how it happens, that even though the proper process of removing the president and the entire cabinet stepping aside didn't happen in either Thabo Mbeki or Jacob Zuma's instances, we did see a type of complete new government because a new person took over as president and did shuffle his cabinet as he saw fit.
Thank you very much.
Then there was some other question. I don't know if there are any other questions yet. Okay, so yes, Zakele, yes, I had forgotten your name there. Zakele?
Yes, Prof. Thank you very much, Prof. Prof, firstly, I just want to, I'm sorry, I've just joined late. I just wanted to check as to which chapter are we in terms of the textbook. But again, I just wanted to check as to if you compare the two processes, the functions of the president appointing the ministers or the cabinet with the appointment of the Chapter 9 institutions, in terms of the process, how does it differ? I mean, between the two processes.
Okay, so we are now in Chapter 4 of the textbook, and obviously that's why this whole discussion is about the president, because what we're looking at the moment is how the president is accountable to the National Assembly. So Chapter 4 deals with the National Assembly, but a large component of that chapter deals with how the National Assembly is the body that officially appoints the president, because it's within the National Assembly that election takes place as to who the president will be. And the National Assembly is then the body from which the majority of members of cabinet will come from, besides two. Remember that the president is allowed to choose two people who are not members of the National Assembly as members of cabinet, but all the others are persons who have been legitimately elected in terms of the elections and have assumed their role as a member of parliament. And the president then says, you, Praveen Gordon, just using it again as an example, I want you as my Minister of Public Enterprises. You, Toko Didiza, you're my Minister of Agriculture and Rural Development and Land Reform. So they all sitting there in the National Assembly already, and the president then appoints them. There is a vast distinction between how the public protector, I'll use public protector as the sort of generic Chapter 9 institution. The distinction is that when a new head of the public protector's office needs to be appointed, that is a process articulated in the Constitution, because it says that there shall be the calling for a nomination, for a number of nominations, and that the National Assembly members interview the shortlisted candidates and they make the recommendation to the president about who should be appointed. But because it was those members of the National Assembly who then decide, or unanimously, hopefully, decided who should be appointed, they therefore have to play the role of removing or impeaching that person. So the distinction is just that the members of cabinet are appointed without the necessity of any interviews, and it is a straightforward process. I've lost interest in you being my minister. From tomorrow, you're no longer a minister, or from tomorrow, you're Minister of Minerals and Energy, and I'm shuffling my cabinet. Whereas with a Chapter 9 institution, that head can only be impeached after a proper process has been followed, where the National Assembly has considered all the material facts and circumstances and can then make not only make a recommendation, but formally vote on whether the person should be impeached. And we know, if we use the analogy of removing a president, that the threshold of votes that is required to remove a person through impeachment is 66.6%. So that is where we see the National Assembly coming together, and there needs to be a quorum, in other words, enough members to be involved in this decision, and they formally vote so that the correct decision that can be seen as legitimate and credible and justifiable is taken. So I don't know if that's answered your questions fully.
Yes, thank you, Prof. Thank you very much.
Any other questions at the moment? If not, then let us carry on with our discussions on Chapter 4, because we got as far as, I think it was page 5, and then I tried to delete a few, or some of the spaces to make it less pages in total. So we got to the point where we were, and this is very pertinent given our previous discussion, we are now at the point where we are discussing, and let me try and share my screen again. Yeah, we are discussing the powers of the Speaker. And so it can't be said enough how important the role of the Speaker is, because as you'll see in the textbook, the Speaker is the public face of the National Assembly, and therefore he or she must preside like a judge. So the word preside is important. They have to be the chairperson, if you want to use a term that's probably more relevant. That they, at every meeting, they are in a position where they take control, they regulate how Parliament is going to function, they keep discipline, and that is important because of the cases that come later on. And they ensure that administratively the National Assembly functions how it was intended in terms of the Constitution. And that's why we insist, in theory, let me say, that the Speaker is supposed to be above party politics and must at all times be impartial and I have to use this expression, demonstrate the same kind of impartiality that we would expect of a judge. So that is why we say that the Speaker must act not in his or her own interests or for the interests of his or her party, but must act purely to achieve the purpose for which the National Assembly was established. And that is, as we know, to ensure that the president is elected at the first sitting after elections, that laws are passed following the correct procedures, that at all times the executive, so the president and cabinet, and the executive in general, if necessary, are accountable to Parliament. And it's not stated here, and I'm going to sort of jump around a bit just so that we move faster, but one of the fundamental roles of the National Assembly is that if they want to ask someone questions, they have the same power as a court in that they can summons a person to appear before them and to give evidence or information. So if ever there is a shortfall in service delivery, let's say in Tshwane, the Premier of Gauteng or the Mayor of Tshwane, possibly would be a better person, he or she can be summoned to appear in Parliament and actually answer questions. And it is the same idea as if a court has summoned you to appear as a witness. You cannot be in contempt of the court and just not appear without any kind of an apology. It's actually identical with the National Assembly. We are all supposed to respect the role of the National Assembly. And if any of us are in any position where we are required to come to the National Assembly to give information, and they have formally summoned you to give the information, you have to appear. And why I'm emphasizing that now is because with the recent leave of absence that was given to Minister Zweli Mkhize, he was actually initially summoned to Parliament to account to Parliament about what had happened and how he was implicated. But just before he could actually appear, there was then this mutually agreeable decision between himself and the president that he would instead take a leave of absence. And so because he now was on this leave of absence, there was no longer the imperative for him to appear before Parliament, and he was able then to get around the summons that he'd received, a verbal summons. Doesn't have to be in a written form, a verbal summons saying, come and appear before us. He didn't have to do that. And that's where we see that the National Assembly does recognize that if internal party political processes are functioning effectively enough, like removing Jacob Zuma instead of the National Assembly having to vote to remove the president, the National Assembly will give the party the benefit of the doubt if it is consistent with the general will of the people. And therefore, if it's the African National Congress, which is the major political party and which is the party in government, it is seen as being a decision that the majority of the population would deem to be a legitimate decision, and the National Assembly will then not unnecessarily intervene. And I emphasize unnecessarily intervene because we have seen that there are too many instances where the National Assembly did not intervene when they should have, and therefore opposition political parties were forced to go to court and say to the to the judiciary, we are here because the National Assembly is not functioning effectively. And because, as I've just pointed out, the Speaker of the National Assembly is the person who takes ultimate accountability and responsibility for the effective functioning of the National Assembly, those cases are all brought against the Speaker because he or she has failed to take cognizance of the circumstances and to make the correct decision that is a decision that can be justified to the community at large. So the examples, as you've seen in your lecture material and especially in tutorial letter 102, those examples are the classic cases. And I say they're classic because they have fundamentally transformed how we understand constitutional law. Because for months, what we saw happening was the public protector at the time, Thuli Madonsela, handing over her report to the Speaker of the National Assembly on the Nkandla upgrades, because the Constitution says that that's what the public protector must do. And it is then inferred that obviously once that report has been received, something must be done to give effect to it. And instead, the Speaker of the National Assembly tried to use all kinds of alternative methods to prevent President Zuma from actually being held accountable. And that was when the economic freedom fighters said, this is now enough. We have repeatedly asked the president when he is going to pay back the money. We have repeatedly stood up in the National Assembly during the State of the Nation address and have said to President Zuma, when are you going to pay back the money? And I've got it quoted further on, and I just want to quote it again because I think yes, it's coming up soon. So yes, it's here at the top of page 8, where, and I had to watch the video to get the exact timing, but you will recall that 12th of February 2015, President Jacob Zuma stood up in the National Assembly to provide the State of the Nation address, as the president does every year. And as soon as he did so, the EFF stood up. A member of the EFF stood up and said, so now I'm quoting verbatim, may we ask the president when he is going to pay back the money in terms of what the public protector said? Will he pay by EFT, cash, or e-wallet? So you'll realize then that the EFF had got to the point where they were now desperate for accountability, and they took it to the extreme by not letting the president actually speak freely in his capacity as president. And because they were so furious that the Speaker of the National Assembly had let him get away, and they therefore did not view this appearance by the president as legitimate when he was supposed to have been held accountable by Parliament. So as you can see then now, if we go back to the top of page 8, in the first EFF case, because you must remember that there's a 2016 decision and a 2018 decision, both of them are fundamentally important. But it was the 2016 decision at paragraph 95 when the court said, as soon as the public protector handed over that report saying that the president was unduly enriched by the upgrades to Nkandla, because not all of them were strictly security related, that ought to have immediately triggered into operation the National Assembly's obligation to scrutinize and oversee executive action and hold the president accountable. And what we had seen instead is that the Speaker had appointed one ad hoc committee. So an ad hoc committee is just a temporary committee. And so you said to the ad hoc committee, you go look at the public protector's report. And of course, they came back and said, no, there's absolutely no truth to the averments in the public protector's report. The president was not unduly enriched. So then the National Assembly Speaker sent the report off to the Minister of Police and said, you tell us, were these upgrades strictly security related? And the Minister of Police also said, yes, they were strictly security related. So the emphasis here is where, and I said this early on, and I know it's contentious, but it appeared for all intents and purposes that the Speaker of the National Assembly was colonized by her position as a member of the African National Congress, and therefore could not separate her role as a member of the African National Congress, who had pledged allegiance to the party and to the leadership of the party, and her role as the Speaker of the National Assembly, where she was supposed to demonstrate the same independence and impartiality that we expect of a judge. And that's why the economic freedom fighters had to go to court. So the chapter, or the next three chapters, so 4, 5, and 6, are all titled The Separation of Powers and National Assembly, Executive, Judiciary, to tell us that it's not on a sort of a whim that a political party will rush to court to resolve political issues. In fact, our courts have repeatedly said courts are not the right place to resolve political issues. They must be resolved internally. And the National Assembly itself should have resolved this issue a long time ago by dealing effectively with the Public Protector's report. But because they didn't, is why the EFF went to court saying, we want an order that the president is in violation of his obligation in terms of Section 83 of the Constitution. Yes, is there a question from someone? Was someone asking a question? No. Okay, so all I'm indicating to you is that it's only as a last resort that reference should be made to let us institute litigation to resolve the issue. But the EFF were now absolutely furious, and they therefore said, we need this court to make a number of orders. Firstly, we want this court to declare, and I think this is an interesting term that applies very well to our National Assembly, but that the president is a constitutional delinquent because he had not complied with the Constitution, where Section 83 says the president is this constitutional being. He's established in terms of the Constitution and must comply with the Constitution at all times. And that is the importance of this case, is also the fact that it now gave absolute clarity to the status of the findings of the Public Protector's Office. Because up until 2016, there were numerous instances where the Public Protector had said a certain individual has failed in their constitutional obligations and they should therefore be removed from office, and that there should be serious consequences. And those serious consequences never ensued. And it's only subsequent to the 2016 decision where our courts unambiguously said, decisions of the Chapter 9 institutions must be implemented in good faith and as a matter of priority. But more importantly then, as far as the functioning of the National Assembly is concerned, and the fact that it is the Speaker who has this important role to play, is the UDM case, which I've mentioned repeatedly, but just for clarity's sake, I'll reiterate, is you will recall that at one of those stages where there had been a motion of no confidence brought to the Speaker of the National Assembly's attention against Jacob Zuma, and the Speaker of the National Assembly was asked by the UDM, please make this a secret ballot so that the people in this Parliament can vote with their consciences and not be bound by party strictures. And the Speaker, you will recall, said, I have no power to decide such a thing. And that's why, again, out of absolute desperation, the UDM had to go to court and say to court, please, will you make a declaration that is binding, that informs the Speaker of the National Assembly that she is given such immense powers to regulate the effective functioning of Parliament. Surely this includes a decision about whether or not the vote should be secret or not. And that's when the court proved this point by saying the Speaker definitely does carry this immense responsibility to act impartially, and she must be able to make appropriate decisions. And they therefore said, she does have the power to decide whether or not the vote should be secret. We are not going to tell her which way she should go. She must do what she thinks is best. And ultimately, it was a secret vote because she realized that the law was leaning towards her having the power to make it a secret ballot. And because of the repeated pronouncements by the court about the need for the integrity of the National Assembly to be upheld, she did decide, let us make this vote a secret ballot. And the vote went ahead. We know that it wasn't a successful vote, but it was still a vote that was secret and therefore satisfied the needs of the minority opposition parties who were afraid that if it wasn't a secret ballot, it would have been a very different outcome in terms of the number of votes. So the essence of what I'm trying to say here is that the National Assembly is run and managed by the Speaker as though she is the manager of a big corporation, meaning she needs to make the rules in consultation with the National Assembly members, but ultimately ensure that there are appropriate rules in place to regulate any incident that may arise. And you'll recall then from the Oriani Ambrosini case that I've discussed before, even though the rules of the National Assembly at one stage said, if a member of an opposition party wants to introduce legislation, they first need to obtain permission. And so Oriani Ambrosini had to go to court and say, surely this is an invalid, unconstitutional rule. And the court said, indeed it is, and the situation must be rectified so that any member of the National Assembly can introduce legislation in Parliament. Likewise, the importance of the 2018 EFF versus Speaker of the National Assembly case is precisely the same concept, where rules had not been properly adopted to regulate precisely how a president, and if we use it now by analogy, the public protector, must be impeached. Because there was no proper committee that had ever been established to carefully and thoroughly and impartially consider all the evidence against the president and therefore be able to convincingly say to the speaker, we as this committee looking into whether the president should be impeached are of the belief that on face value, or prima facie as it's known, there is sufficient evidence. Not that we must now immediately fire him, but there's sufficient evidence to necessitate a vote taking place. And it was that missing link that had to be rectified in the 2018 case. So that's why Parliament had to come up with rules about the exact manner in which it will deal with impeachment cases and create a subcommittee to analyze the facts, analyze all the evidence, and then make a recommendation so that that recommendation can be voted on. Because even if the president had been impeached previously, he probably would have been able to contest it by saying, this is an arbitrary vote. No one has actually stood up in this parliament and said what it is I've done wrong. And I actually sound quite now like that I'm quoting Jacob Zuma. But that is what he would have been able to say if he had been impeached. He would have said, where is the evidence before this forum? Because no one ever would actually bring the evidence and say to everyone else in Parliament, these are all the material facts and circumstances which necessitate us taking a vote. It was I can't not use the word arbitrary process. It was a process that was far too easy to manipulate. And now we have rules in place stating that there must be proper consideration of the circumstances. And if a recommendation, and I think the better term is a resolution, is then given to the speaker saying there is enough reason to impeach the president, then a vote can happen. And now in future, that situation is regulated, and that is precisely what is supposed to be happening in the context of the public protector. Although, as you've seen in the news, the public protector has gone to court to try to stop the National Assembly from actually taking that decision against her and deciding by way of a vote whether she should be impeached. And that's why we see Thandi Modise, who is the Speaker of the National Assembly, acting in terms of her powers vested in her as the Speaker, saying, but we as the National Assembly are the correct forum. The court cannot tell us how to perform our task. We already know what our failings were in the past because of the second EFF case. We've now got these committees. We've made sure that people with the relevant expertise have considered all the information carefully and thoroughly, and we will only vote because there is this overwhelming evidence compelling us to vote on an impeachment. And it doesn't necessarily mean that the public protector will be impeached anyway. The African National Congress members who have the majority in Parliament might all vote not to impeach her, along with the EFF members and some others. So she might not be impeached anyway, but the proper procedure has to be followed. And that then brings us to our discussion about how you become a member of the National Assembly, which we probably should have discussed earlier on, but I think I just tried to make it sort of more logical in my notes about, let's assume now there is a National Assembly. now we can look and what the National Assembly is there to do. Now we can look at who is a member of the National Assembly. And we know that a member of the National Assembly is a citizen. I have to emphasize that because Section 19 of our Constitution does make that qualification that only citizens are actually entitled to participate in our electoral processes, and therefore only citizens are eligible to be members of the National Assembly. And that therefore it must be a citizen that is free. In other words, they're not also employed by the state in the Department of Social Welfare, for example, where they're receiving a salary. That person is not eligible. They already have their job. They must either resign from that job and become a member of the National Assembly, or keep their job and ignore their request to become a member of the National Assembly. So that is one of the most important qualifications, is that you have to be a citizen who is not already being paid by the state for any services rendered. Then the term of office is ordinarily 5 years. We know that that has happened where we've had this discussion previously, that it's only ever been the president in 2 instances who has been removed through a resignation. So I say removed, but that sounds a bit harsh. And we saw then that all other members of the National Assembly generally just continued in their functions, unless, of course, they died or for some reason decided that they were leaving the ANC and now were going to become a member of the Economic Freedom Fighters. That, and it's in the next section, which shows how a person loses their seat, but that is called floor crossing. And if a person has been duly elected as a member of the ANC, for example, into the National Assembly, and they then decide to resign from the ANC and become a member of the DA, they lose their seat in Parliament, because otherwise it would mean that the DA are through the back door getting more seats than they're actually entitled to. So it's ordinarily a term of 5 years or until the next election. So that's generally give or take 5 full years. Then you are eligible to be a member of the National Assembly if you are actually properly, I want to say compos mentis, but you need to show that you have the skills and you are not prohibited from being a member because of some mental failing on your part or some other reason that makes it incompatible with your objective of being a member who is responsible for passing legislation. So those are the essential eligibility requirements, that you must be a citizen and you must be someone who can now become an office bearer of the National Assembly, not having side jobs where you're earning money off the state, but you must be able to dedicate all of your time, energy, and effort to being a member of the National Assembly, because that is now your new position. Ineligibility for being a member of the National Assembly is obviously if you're not a citizen, but it also includes a large group of people who are deemed not eligible for a number of reasons. So the most important reason that someone would be declared not eligible to be a member of the National Assembly is if they are already a member of the National Council of Provinces. So you can't be both a member of the National Assembly and the National Council of Provinces if you are a permanent member of the National Council of Provinces, because you cannot be in two places at the same time. So that's an automatic reason why you can't be a member of the National Assembly, and it's a perfectly justified reason, because you're already a member of a legislature, but it's just the National Council of Provinces representing your particular province, and you cannot therefore also be a member of the National Assembly. Secondly, if you have been declared bankrupt and a court has officially declared you insolvent, and let's say 9 years have passed and you've had a good management of your money over the last 9 years, unfortunately, you are still deemed to be an unrehabilitated insolvent, because you only are deemed to be a rehabilitated insolvent after 10 years. So that's the threshold. 10 full years after you were declared insolvent, then it is as though you've righted the wrongs of the past, you've now learned how to manage your financial affairs better, and now you can be a member of the National Assembly. So that is a defining characteristic. You cannot be so severely in debt that you've actually been declared insolvent. Very importantly, you also cannot be someone who has been declared by a court as being of unsound mind. So that's very much what I said above. You've got to be able to actually perform the functions of office. And if there is any mental instability, even though the Constitution says you cannot discriminate against someone on the basis of their mental capacity, if they are simply unable to execute their tasks because of this mental impairment, it's a legitimate reason for them not to be a member of Parliament. Then an interesting one is, if after February 1997 you were convicted of a criminal offence, sentenced to over 12 months in prison, and without the option of a fine, then you are not eligible ever to be a member of the National Assembly. So that is illustrating that the people who are supposed to be members of the National Assembly should be the persons who display integrity, ethical conduct, and have therefore not been found guilty of any criminal offence within the Republic. So, of course, if it's less than 12 months imprisonment and there was an option of a fine, perhaps for driving while under the influence of alcohol, you can still be a member of the National Assembly. It's not desirable, but it's permissible. Then importantly also, if you are elected as a member of the National Assembly and you decide that you want a long holiday, and I'm wanting to just differentiate between when a party gives their member sabbatical, because we've seen in the news recently the Van Dam situation where the DA said, we've put you on sabbatical. Sabbatical means that you're actually still in the employment of that entity and are still being paid, but you're given a leave of absence, a legitimate leave of absence. But in this scenario, what we're looking at is not someone who's been given any kind of a sabbatical, but they simply don't arrive in the National Assembly when they are supposed to be there for an extended period of time. So the sort of parameters are if it's a period of more than 15 days, so 2 solid weeks. Then the rules say that automatically the person ceases to be a member and will automatically lose their seat. So you see that there are serious consequences, but it's the same as if you are in any other position and employed by someone. You can't just not go to work and expect to get away with it. It's the same idea. You have to be there and do the work that has been given to you to do. And so the last one is the one I spoke of earlier, floor crossing. So when you decide I've had enough of the African National Congress, I'm now moving to the IFP, you do lose your seat because you got the seat in your capacity as a member of the African National Congress. And so you're no longer a member, you weren't ever on the IFP's list, you don't have a right to remain in Parliament. Or if you've been expelled from Parliament, and that is a contentious issue. I must say I can't remember all the details, and I haven't seen anything on it for a while, but there were allegations at one stage that a number of EFF members had been expelled from Parliament and were now going to court to challenge that expulsion. And I don't know whatever happened. So if you do know what the outcome of that was, you can enlighten us, but the principle being your party can expel you from Parliament, and the Speaker can expel you for consistent bad behavior or disrupting the Parliament in such a way that the general party business of the National Assembly cannot be conducted as it should be. The National Assembly has very wide discretion to decide the time of its sittings, the duration of its sittings, when it will have its recess periods. So it will usually have its recess periods, over sort of major holidays, like I would say Christmas and Easter. But there are various times where it's necessary to give the National Assembly members a break, so a recess, and then call them, well, after that recess, they come back and then they continue their business. There are only two instances, as we've been discussing quite a lot tonight, about when the National Assembly would cease to operate and therefore an entirely new election would have to take place to reconstitute the National Assembly. And the first is when the president says, I am invoking my rights in terms of Section 50 of the Constitution to dissolve the National Assembly. So that really is a serious decision, saying, I want to dissolve this entire House. And in order for that to happen, there has to be an election, a vote on the dissolution. And if the majority party does have enough votes, because it would require 66.6% of the votes, because this is of such serious magnitude, it is permissible for the president to say, I now put it to the Speaker that we vote to dissolve this Parliament. But there is one requirement, that the Parliament must already have existed for 3 full years. So the president cannot arbitrarily decide after a few weeks, I'm really not loving this Parliament, I want to change its composition completely and let us have a whole new election. And why there's that safeguard in place is because there's this general sort of common cause that there are certain times when a political party might have more of a following than at any other time. And so there is this possibility for the president to try to take advantage of that situation and try and dissolve Parliament so that they might get a better majority. That party would get a better majority in the subsequent elections. Fortunately, we've never had to deal with a situation like that. So that's not likely to happen, I wouldn't say. We've got a system in place where our parliaments generally sit for 5 full years. It's only ever the president who's had to leave office and not the entire National Assembly. Then in terms of Section 50, subsection 2, if the president has had to resign in terms of Section 89 because of his inability to perform the functions of office, or he's died, or was removed in terms of Section 89. So you'll remember Section 89 says the president can be removed or impeached if he or she has been engaged in a serious violation of the Constitution or a serious violation of any other law. In that situation, we know that the office of the president would become vacant because he's been removed by a vote of 66.6%. And if it wasn't in terms of Section 89, we know that the alternative is Section 102, which is a motion of no confidence when the political party itself has lost the confidence in the president and says to the speaker, we are wanting to initiate a motion of no confidence so that you can then determine the date and time of this vote, and we will come and vote. And in that case, all that's required, as you'll recall, is 50% plus 1 extra vote to make it clear what the majority decision is. But because of the way in which our president has been or vacated office in the last 2 instances, we haven't had to deal with this situation of a 30-day vacancy occurring and then a whole new National Assembly having to be created. It's never, fortunately, as I say, never happened this way, because we can imagine how disruptive this would be to the effective functioning of the state. And so we are fortunate also then that a president has never, for example, died while being in office, because that would necessitate the dissolution of Parliament and an entirely new election taking place. So that is why the African National Congress have resorted to using their own internal party mechanisms in the other 2 instances to make the whole process as fluid and seamless as possible and not have to have an entirely new election, which costs so much money and is very difficult to administer, because you've got to ensure the registration of voters and the subsequent election and then the counting of the ballots. So you understand that it is a serious consequence when the National Assembly has to be dissolved. And so it has been avoided, fortunately, in the past. So those are the only 2 real instances that you need to concern yourself with how the National Assembly would be dissolved. And fortunately, we've never encountered them in practice. Most importantly, and I keep mentioning this in any event as we discuss things, that there are always voting thresholds that have to be obtained in order for decisions to actually be legitimate and credible. So when the National Assembly takes a vote on any question put before it, let's use the example. If someone from the EFF stood up in court, rather in Parliament, and said, when is the president going to pay back the money? Is it by e-wallet, EFT, or credit card? And there are only 50 people in Parliament, for example. There has to be a time limit, and the maximum then is 15 minutes, in the hope that within that 15-minute period, more members would arrive, because you will remember that the absolute minimum limit of members who must be in Parliament when any decision is taken is 134. So if after 15 minutes there are still now only, let's say, 75 members of the National Assembly present, then unfortunately the Speaker has to ring a bell, and that indicates that there is no quorum and no decision and no vote can take place on that question posed by the EFF, for example. So that ensures that decisions are only ever taken when there are the absolute minimum number of National Assembly members in Parliament. Otherwise, we could see all kinds of decisions being passed that are not consistent with the Constitution, not legitimate, and we as the general population might never know about it until it's too late. So that's the most important thing, is that there must be at least 134 members, otherwise there's no quorum. Then, when it comes to passing a bill, and you'll remember then the bill will have been initiated either by a member of the National Assembly, but usually by a member of the executive, and it undergoes a process of formulation into the form of a green paper, which is a discussion document. And then the green paper is analyzed by the state law advisors. And then it's converted into a better format, which is then called a white paper. And that is a policy document that indicates to everyone, meaning the entire country, because it is published. It indicates this is what the proposed law will contain. If after public participation has occurred and there have been no absolute rejections of this bill, or there have been very minor objections and the bill has been amended, and after the National Council of Provinces has voted in favor of the bill, so 6 out of the 9 provinces must also have voted in favor to show that the provinces play an extremely important role in the passing of law that's going to affect everyone across the country. So after all of those preliminary steps are over, and this bill is now presented to the Speaker of Parliament, and the decision is, we are now ready as this National Assembly to vote on the bill. Then the Speaker, as the administrator, needs to make sure that everyone in Parliament has had sight of this bill and are able to debate and discuss and negotiate the bill. And once everyone is happy, then a formal vote must take place to bring that law to life. And there we know that what is required is a vote of 50% plus 1. So we need at least 201 out of the 400 members of Parliament present to vote in favor of the bill. And remember that even then, once they've voted in favor of the bill, that doesn't make that bill become a law yet. It still has to undergo the process of being acceded to, which means the president formally assenting to this bill, meaning appending his signature to the law, saying, as of today's date, or the law itself might say in a month's time, this law will become operative. But when the president has signed this bill, only then does it actually become a law. But the president can't sign it until 50% plus 1 of the National Assembly have voted in favor of the bill. Then so number 3 and number 1 are sort of tying into each other, that in general, the lowest threshold for any decision to be taken by the National Assembly is 134 members, which is 33%, which of course, to me, it sounds ridiculous. It's such a low threshold, but that is deemed to be sufficient for purposes of the effective functioning of the National Assembly. But very importantly then, number 4 is when it comes to a vote to impeach either the public protector or the president, 66.6% of the members must vote in favor, and when it comes to amending the Constitution, in general, the same threshold of 66.6% is required, except when it comes to trying to change Section 1 of the Constitution. Remember that Section 1 of the Constitution are the founding provisions. They are the provisions that say we will be a state that is sovereign, independent, autonomous, and that will function according to the values of human dignity, equality, freedom, the rule of law, democracy, accountability, supremacy of the Constitution, openness, transparency. All of those fundamental principles cannot be changed unless a vote of 75% is obtained. And we know that it's not easy to obtain a vote of 75%. So that is the safeguard to ensure that the founding provisions of our Constitution are not arbitrarily or too easily amended. I think just as a point of showing the significance of the Speaker of the National Assembly, we see that in number 4, where if it's an impeachment vote and what is required is 66.6%, and the vote is sitting on 65.8%, for example, the Speaker does have what's called a deliberative vote. So her vote, since it's a woman at the moment and has been, will be the deciding vote, the deliberative vote that will carry the motion, because then there is enough of a threshold. But if the vote is only sitting at 50%, that single vote by the National Assembly Speaker is still never going to be enough. So it's only used when there is the slightest chance that it would change the outcome fundamentally. So I am going to discuss openness and transparency quickly because I've mentioned it at length already. You will recall our elaborate discussions about the Doctors for Life case, where 4 bills were passed governing things such as termination of pregnancy. And when Doctors for Life, which is an NGO, came to be aware that this had happened in secret, they were forced to go to court and say to the court, surely this cannot be sanctioned by the court. That bills that have such far-reaching consequences, especially on the conscience and the moral beliefs of us as doctors, that these bills cannot become operative. And the court agreed. The Constitutional Court said, it is absolutely imperative that public participation always occurs. Citizens must be actively involved in all public affairs, and they must have an opportunity for their voice to be heard. Otherwise, that bill is null and void. I can't actually emphasize that enough, that in an exam scenario, if the question says something like that it took 2 weeks for a bill to become law and it's on something contentious, you should automatically be assuming there was no public participation. And we now know that the court has held at paragraph 300 of the Doctors for Life case that it has extremely grave implications concerning the validity of the conduct of the National Assembly, meaning that they have not complied with the law, and therefore nothing can save that law from being fatally flawed and invalid. So that brings us where I think we might be able to finish on this point, although this is a very extremely exciting point at the moment, is on the same day, you'll remember I've referred to the 12th of February, 2015, when Jacob Zuma stood up in Parliament, ready to make the State of the Nation address. Not only did we know that 4 minutes into it, the EFF stood up and said, we want to ask the question when the president will pay back the money. But what also happened, and it was admitted about a week ago at the Commission of the State Capture Inquiry, it was admitted that Parliament had deliberately used a jamming device. In other words, a device where the cell phone signal of every single cell phone within the entire precinct of the National Legislature became inoperative because the speaker, I have to put the blame where it belongs, the speaker fundamentally wanted to protect the president from embarrassment. And so Prime Media Broadcasting, who were relying on cell phone signal and on what is the DSTV, can't remember what it's called, but you know, when you have a satellite dish, all of that signal was now suddenly jammed. So and what we saw was a black screen on TV. So we, sitting at home, had no idea what was actually happening. But this was all done to try to protect the reputation of Jacob Zuma. And that was when it was contested in court. Prime Media, as a dominant member of the industry, had no option but to go to court and say to the court, you need to make a declaration that what the Speaker of the National Assembly and the National Assembly as a whole did by using that jamming device actually resulted in the public not being given an opportunity to participate in this important process of hearing what the president has to say. And so the court did have to use the test of, is it proportionate of the National Assembly to jam devices to protect the president, or could they have done something else? And the court ultimately said there was certainly no justification for the use of a jamming device. They should never have contemplated using any such device because it does impede our ability to listen to the president and hear what he has to say, even when the EFF were asking him to respond about when he's going to pay back the money. So that's why the Supreme Court of Appeal in the Prime Media case did say the jamming device was unconstitutional, invalid, and must never be done again. Why I say it's interesting is because throughout the case, the National Assembly representatives, or the legal representatives speaking on behalf of the National Assembly, kept denying any knowledge of a jamming device and denying that they'd done anything. But it did come out recently at the State Commission inquiry that, in fact, this had happened. So what it proves to us is that Section 59 of the Constitution must be protected, because Section 59 ensures that the public must never be excluded from participating in the workings of the National Assembly, and that automatically involves the media, because it's the media who are there to get this footage, to transfer it onto our televisions for us to see as it happens. And we were being denied that opportunity to actually be part of this important day in our annual calendar. So I've already mentioned that. I'm going to end here with the case from 2016 that actually dealt with the very same date. So a lot happened on the 12th of February 2015, as I'm sure you've gathered. There was a State of the Nation address. We had a jamming device. We had the EFF asking the president to pay back the money. But what ultimately transpired, which was probably even more troubling, is that as soon as, and by this stage, the jamming device had now been switched off so we could all see this. But what happened then is members of Parliament, so it was EFF members and DA members, were then relatively disruptive, because they were angry about the jamming device, and the EFF wanted a response to their question about when the president will pay back the money. And even though we are supposed to, in our minds, recall that the legislature and the executive are separate from each other, what the Speaker of the National Assembly did is she called the Sergeant at Arms and I have to emphasize this, the Protection Service officers. So in other words, what the National Assembly then did to restore order, although all it actually did was aggravate the situation and result in assaults against members of Parliament, but the Protection Service officers are actually members of the executive. They are policemen employed in the executive branch of the state. And those Protection Service officers were not meant to intrude into the legislature and harass and forcibly remove those members of Parliament who were deemed to be disruptive. So you can hopefully gather that the DA were genuinely concerned for their own account and on behalf of the members of the EFF that their sort of protection in the National Assembly was now violated by members of the executive entering with the permission of the Speaker and forcibly removing them from Parliament, which was then denying those same members their freedom of speech. And we know that members of the National Assembly have the freedom to say pretty much what they want in Parliament. They can make quite disparaging comments. They are not supposed to. So the idea is that what should be used is what is termed parliamentary language. But we've seen that sometimes discussions do get heated and there are insults between the various parties. But that is generally protected by the parliamentary privilege of freedom of speech, so that the nature of our parliament, which is pluralistic because it's composed of so many different people representing different parties and different interests, they should be allowed to say whatever they want if it's going to advance our democracy and allow them to meaningfully participate on behalf of the people who have voted for them. So there should never be a fear of any threat that a member of the National Assembly will be arrested or imprisoned or sued civilly for saying anything in Parliament. And that's why the Constitutional Court in the DA versus the Speaker of the National Assembly case had to give a proper interpretation of what would constitute a disturbance in Parliament. And here we see that the Constitutional Court had to take a narrow approach. So remember, in the case of the New Nation movement, the court gave a broad interpretation to Section 19 in order to give better effect to Section 57 of the Constitution and to the imperatives of the Electoral Act. Whereas in this case, because we know that our members of Parliament must be able to speak freely on our behalf, the Constitutional Court interpreted disturbance in a narrow fashion and said only when it becomes absolutely unmanageable would there be any need for some kind of intervention. But in the general context of the functioning of Parliament, you can't arbitrarily, and I have to keep saying arbitrarily because I think it is the most appropriate term, you can't arbitrarily bring in the police to remove members of Parliament, because there should be internal orders and rules governing how Parliament should function, governing parliamentary privilege, protecting the members of Parliament, and there should be no ambiguity about what is protected and what isn't protected. And therefore, the general impression is that for the most part, there must be the ability to say what it is you need to say. And so I'm going to end it there, because that comes on next is actually what we've discussed before. And I'll say it very briefly just to remind you, is you will recall in the very early days of Parliament, when Patricia de Lille was then a member of the Pan-Africanist Congress, and she stood up in Parliament and said, people here, some of the ANC members here are spies and were spies for the apartheid government. And she was suspended from Parliament. And that's where this decision on parliamentary privilege was sort of concretized. And we now know that for the most part, members of the National Assembly have the freedom to say whatever they need to say in Parliament, to make sure that everyone is ad idem, everyone understands, everyone hears each other's concerns, can listen to the other side and make a decision based on that, and that the member of Parliament should not be suspended, because that would impair their ability to speak on behalf of the people who have put them there. But ultimately, what has happened subsequently, and I think probably because the African National Congress didn't want to find itself in a similar position to the de Lille case, where it had been told, sorry, Speaker, you've made a fundamental mistake. So now rules of Parliament have been adopted. So it's rules 70 to 74 that say that it is, in certain limited and specific circumstances, possible to suspend a member of Parliament for between 5 and 20 days. but only if the circumstances are absolutely clear in justifying the suspension of such a person, because the general belief is that the Member of Parliament is there to represent their people and that they should conduct themselves in an orderly and disciplined manner. But if they do go overboard and things do get out of hand, and I do want to use the example here of our Pan-African Parliament, where things did get out of hand in that parliament, then certain members should be able to be suspended so that they are taught that that is unparliamentary and the parliament of the country will not tolerate it. So that brings us to the end of page 8. Now, we do still have about 10 pages left, but you'll remember that next week I'm continuing with this. Then I'm going to discuss chapter 5. And as far as I can recall, it's only from the 2nd of July that Professor Shai will be taking over, talking about the judiciary. And so we've still got a lot of time. That's what I'm trying to say to you. So don't panic. I know I'm actually moving quite slowly, but a lot of what we say is repeated in any event. So I noticed, as did you, that Professor Shai and Mr. Mudau, who will be lecturing in future, have asked to change the time to 3 o'clock. Now, I certainly hope it is a possibility that you can attend at 3. I'm still happy to continue at this hour, but they aren't, because they have to work from the office. For example, one doesn't have internet at home, and it's just too late for a Friday night, they say. So I'm going to end our discussion here. I do want to just say, if you have any serious objections to the 3 o'clock, you could write an email to Mr. Mudau or Professor Shai, but I don't think there's much chance of you succeeding, because we've all got to accommodate each other. I think that's the thinking here. All right, so are we all okay at this stage?
Yes,
Omar
ma'am.
Bosaletsi. Sorry, I never saw your hand because I was showing my screen. Omar Bosaletsi.
Yes, ma'am. The name is Litum. I'm using the different device.
Okay, all right.
Due to load shedding.
Yeah.
Yes. I just want to know that 2 things here. In terms of you initially mentioned that the member of parliament might not take any employment in any of the government. Is it only limited to government? If you are employed somewhere else, well, I'm thinking of maybe Dalimpo, who is a lawyer in the EFF, but is also a member of a National Assembly. And also another second question is that you mentioned the issue of that the speaker can what was the right word? Can dismiss someone from parliament who's constantly disruptive.
Yeah,
Is it
expel.
Yeah, can expel. Is it permanently so? Because now I'm thinking that if, let's say, you expel someone from maybe EFF or any other party, now you'll be denying that party the right to voice out their objections. Is it like something that is on a permanent base, or is it only for that sitting?
Well, no, those are excellent questions. The first one, the terminology for which members are ineligible for to be appointed in parliament is anyone who is working for the state. So there is a lot of emphasis there on, if you work for the state and you earn an income from the state, you then can't also earn another income from the state by being a member of parliament, especially if it's going to clash with your ability to perform your functions effectively. But your example about Dali Mpofu is a very good point, because he wasn't working for government, he was working for himself, and also able to manage both, manage being a member of parliament and being available for sittings where he had to be there because votes were being taken, but he could still manage his private legal practice. So the requirement was only you can't be employed and be earning an income from the state. And that's very important to ensure that you are then working as an independent person in the National Assembly and for the interests of your voters, but for the society as a whole, and not for the government, that you don't feel, beholden to the government because you already work for the government and now you working on the side, if you will, for the government. So that seems to be the logic, is that you just can't work for the government. But if you can manage, and I don't know how many would, because most parliamentarians are full-time members of a political party and they have all sorts of functions that they fulfill there. But if you can manage a side job that allows you to do both, there isn't really any restriction. And I think Dali Paul, for example, is an excellent one. Then the question, that's the thing I asked you as the students, because I can't remember what happened, but there was a stage when a number of EFF members were expelled. And I'm sure that they were challenging their expulsion, but I don't know whatever happened. But as far as I understand, that expulsion is can be a permanent expulsion from the, because that's the word, expulsion. If it was just a suspension, it would convey that it's temporary, but expulsion means a permanent removal from this body, the National Assembly. So I must say, I don't recall what happened with that case, because I think it was a number of EFF members. What might have happened is that a new election happened and the matter became moot and purely academic, and that's why it was never pursued further. I just can't remember. So that I don't have a good answer for the second one, but to me, if you take the interpretation of expulsion, it means permanent, and therefore it is for the rest of the duration of the National Assembly's existence, not just for that single day's sitting.
Oh, all right.
So that's how I interpret it.
Okay, so those members were expelled by the speaker, not by...
Well, that's what I understand, is that the speaker is the one who said, you are far too disruptive, you're not complying with the parliamentary rules, and you're now expelled from this legislature. And I think they were in the process of challenging it. That's the best I can remember. I just can't, for the life of me, remember what happened ultimately. But I know that there were, I think it was 14 EFF members who were in this predicament, that they were now no longer actual members of the National Assembly and therefore couldn't represent the EFF, and it was going to impact the outcome of various decisions. So it was problematic, and that's why they were trying to challenge it, but I don't know, I cannot remember what happened. Hopefully, Professor Shai, when he talks about the judiciary, will remember that. He might, because he said he's particularly soft on the judiciary, meaning he loves the judiciary, and it's functioning. So he might remember that case better. I'm afraid I just cannot at the moment. Are there any other questions? Are we all happy? I know it does seem as though we're taking a long time, but you will see that how the National Assembly operates is actually repeated virtually verbatim as how the National Council of Provinces operates. So the notes look longer than they really are. So that's what I'm saying to you. Take it easy. I actually wanted to start my lecture by saying this to you. is that the problem with university is that semesters are so short and no one can really absorb information in such a short space of time. So we are lucky in a lot of respects that this is an extended semester and we have this opportunity to have lectures, because I know that I now only feel like a human being again because I've got time to read. Whereas before I was trying to read things and not always understanding things and not being able to fully internalize information. So that's what I'm saying to you, that I'm trying to go through this sort of systematically and quite slowly so that it makes sense and that you don't just learn to pass the exam, but you actually can remember most of it going forward. All right, so I know I'm now just going on and on when everyone wants to leave. So are we happy to leave our lecture here tonight?
Yes, we are.
Thank you, ma'am.
Okay, so next week again, 6 o'clock.
Yes.
Right.
Thank you.
Thanks very much.
What a wonderful class.
Prof,
Okay, good.
thank you.
Thank
Great
you.
class. Thanks, ma'am.
Bye-bye. Bye.
Cheers, guys.
Thank you. Bye-bye.